Welcome to our webinar this evening. My name is Emilia Onyema. I'm a professor at SOAS, University of London, and I am the director of the SOAS Arbitration and Dispute Resolution Center. We're hosting this webinar in collaboration with CEDA. SOAS Arbitration and Dispute Resolution Center is a research and knowledge exchange center. So it's an academic center. We don't administer arbitrations or mediations, but we do research and we do trainings and we do knowledge exchange regarding those issues. And this is one of the events that we host. So this event is being moderated by my fellow management committee member, Professor Hiro Aragaki. I'm going to hand over to him. He would introduce himself and members of the panel. It should be an exciting discussion. Earlier today, I was involved in a webinar and we were talking about arbitrators becoming involved in mediation and doing settlement discussions, having settlement discussions with the parties, and how that operates in practice. And I was telling people about this particular webinar, and that it sounds as though the mediators are beginning to want to be a little bit more adjudicatory in nature. So we'll see how that goes. And colleagues in arbitration are waiting to listen to the webinar and to watch the recording. The last thing for me to say before I hand over to Hiro is that this webinar is being recorded. So hopefully we have your consent. If you do not wish for us to record, please feel free to leave the webinar. And when we publish the recording, you can listen to it or leave your camera off. If you have questions, please use the chat function. We want an active discussion going on in the chat. We have not muted people, so that out of respect. But if you misuse this, we will mute you. So please, no talking. Please use the chat function to engage with the discussions. I'll hand over to you, Hiro.
Thank you so much for that introduction, Emilia. As Emilia said, my name is Hiro Aragaki. I'm an independent arbitrator and mediator. I'm also an academic based in the United States where I teach ADR and other business and commercial law courses. And I'm privileged to be able to have an affiliation with SOAS as well as a professorial research associate. And really to be a part of this amazing panel. So thank you so much for the opportunity, Emilia. And thank you, CEDAR. We're so pleased to be able to collaborate with CEDAR on this webinar series. This is the second collaboration that we have with CEDAR, and I'm going to introduce Andy Rogers and give him a chance to also say some words of welcome. So we're fortunate today to have a panel of very highly accomplished mediators from around the world. So I want to start by introducing them. Andy Rogers is the first on my list. Andy is a practicing mediator, trainer, and member of the leadership team at CEDAR. He has worked on over 100 disputes across varied sectors, and his clients range from private individuals through to multinational organizations. Andy is also a trustee and board director of the Civil Mediation Council, where he co-chairs the Standards and Registration Committee. He has played a key role in developing standards for commercial mediation in England and Wales, and he's also a trustee and board director of the International Mediation Institute, or IMI. Next, we have Tat Lim. Tat is an IMI certified mediation advocate and mediator based in Singapore, who acts in complex mediation, litigation, and arbitration matters. He is regularly appointed by leading institutions, including SMC, SIMC, AAA ICDR, ICC, WIPO, and the World Bank Group. Recognized by Lexology Index as a global elite thought leader and by Chambers as a global market leader, Tat also serves as regional project director of the Weinstein International Foundation and as chair of the IMI. Andrew Goodman is next on my list. Andrew has been a CEDAR accredited mediator since 1993. practicing in commercial, property, construction, development, transport infrastructure, partnership, franchising, professional negligence, workplace, higher education, and family business disputes. Wow, that's a long list. He is a director of the College of Mediators, a fellow of the Civil Mediation Council, and a member of the Independent Standards Committee of the IMI, among many others. He's also worked all over the world and is acknowledged as one of the world's leading specialist mediation and advocacy trainers. Judge Gerald Rosen is our next panelist. Judge Rosen has served for almost 27 years as a United States District Judge in Michigan. He was the chief mediator in the Detroit bankruptcy, the largest municipal bankruptcy in American history, which concluded in a fully mediated consensual plan of adjustment in just 16 months. He's the author of The Grand Bargain, the inside story of Detroit's dramatic journey from bankruptcy to rebirth, as well as numerous other books and articles. He is now a mediator and arbitrator with JAMS, where he handles large, complex disputes of all types. And last but not least, my friend Aşiyan Süleymanoğlu. Aşiyan is an international legal consultant, mediator, and business and human rights expert based in Turkey with 25 years of experience. She serves as a mediator for the U.S. International Development Finance Corporation, the United Nations Global Mediation Panel, and the Unified Patent Court. An IMI accredited mediator since 2013, Aşiyan has conducted over 2,000 professional mediations with a focus on workplace disputes and social compliance. She's the founder of Akina Consulting. So as you can see, we have a truly stellar lineup. Let me now turn it over to Andy Rogers to say a few words of welcome from CEDAR.
Thank you, Hiro. I'll be very brief, just to say CEDAR's delighted to be collaborating with the SOAS Arbitration and Dispute Resolution Centre again on this event. It's a very important issue and one of the challenges, I think, which CEDAR is aware of, because to date we've trained over 10,000 mediators in over 70 countries, is different mediation terms can mean different things to different people, and levels of knowledge can vary widely. So events such as this that help share knowledge and experience, give different perspectives, can be incredibly valuable. So CEDAR is very pleased to be participating in this, and I'm very pleased to see so many friends and colleagues online to be part of this evening.
Terrific. So we have a large panel, as you saw, but we also wanted to make this as interactive as possible. So the way we're proposing to do this is, rather than individual presentations, as a moderator, I'm going to try and foster an informal conversation among the panelists about a number of topics. And as Emilia said, we invite you to ask questions throughout the session, but only by using the chat function. Please don't raise your hand or unmute yourself. I'm going to monitor the chat and pick out questions that I think would benefit from being posed to the panelists in the moment. All other questions will be deferred for the last 15 minutes of the webinar, which will be reserved for a Q&A session. And at that point, if we exhaust all the questions in the chat, we can open it up to more informal oral back and forth Q&A. Terrific. Emilia has put a question in the chat. Please let us know where you're joining us from. So maybe you could include that in the chat, all the participants of the webinar. So I'm going to start with the first question on my list, and that is, does mediation have more of an evaluative or facilitative complexion in each of your jurisdictions? And what do you think accounts for that? Aşiyan, could I start with you?
Yes, sure. Well, first of all, I would like to thank you and also Andy and Emilia for the invitation. It's a pleasure for me because back in 25 years ago, I was a law faculty student and I decided very early times to become a mediator. So it's special for me to also present in here. If we look in Turkey, the short answer that I can give you is, and if you look by just a law perspective for the Mediation Act itself, is nearly 12 years ago, it's entered into force. It's a quite facilitative model. But when you look the training also, you can say that it is quite facilitative model oriented, and the way that how we train the mediators. But later in 2018, we identify as a mandatory mediation model. It started with labor dispute, and for the whole process extended very much in the other fields as well. And currently, if you look the advanced trainings, it's all based quite an evaluative model. But when you also look the who are doing mediation in Turkey, mostly are legal professions, because it's only allowed for legal professions to do it, and most of them are practicing lawyers. And this creates also as kind of a not difficult distinction between these two models, because there's no like a black and white situation. Is mostly we decide according to the situation, or whether the parties are represented. Do they have a legal representative? Do they also culturally acceptable for the mediation model? So it's all dynamics are changing, and according to who is attending, participating, and whether it's mandatory or voluntary based. So in practice, we have certain flexibility, and this comes also related with the current situation in Turkey. We reach out nearly 9 million cases into less than 10 years, and 5 million settlement. When you look about the data, what public wants, and it's clearly say that they want quicker solutions, and lots of people frustrated about the extended time frames of legal process. But at the same time, for there are social and legal dynamics are various, because in social wise, for instance, is also economical wise, the situation of Turkey, because of the inflation, because of the changes in the recent Turkish lira, and also for social dynamics is refer to for people to find alternative ways. And the other thing is about the legal uncertainty is, and the trust level for the judiciary and also for judges is decreasing by year. And also legislative change is difficult for lawyers to foresee what is really going to happen in the litigation process as well. So these dynamics are making perfect environment for the mediators, but also for us is getting like all the parties is difficult to evaluate. And I want to also make a little bit distinction in this evaluation period, and I see that the more and the more I look about the disputes, and people are deciding not according to the legal situation, they are deciding according to social and economical dynamics. For instance, if I say that there's a labor dispute, if it is not about the labor claims that for lawyers or legal professionals calculated, it's about whether the worker can be replaceable. So if you ask the industries, they have a shortage of labor for the blue collar workers. So even if they have legally right, then they don't want to fire the worker, or because they cannot be replaceable easily, or whether they can adapt the situation or not. Or if you look about the business dispute, then you mentioned that I specialize in business and human rights issues, but legally we are defining them as business and human rights issues. But for the business level, if you ask the global supply chain, they define them as all commercial dispute. So the definition changes according to who you negotiate. in that sense, and so I'm seeing, and my role is about, since lots of uncertainty on the table of others, so I'm trying to get confidence to the process, and as much as evaluate together if it allows us, because as I said, lots of uncertainty and unknown situation is in here right now, make difficult for evaluation, and for not just us, for the also parties. The more I evaluate, the more I take responsibility. So that's why, and I prefer to stay in a level much more facilitative side, and deal, make the settlements in these conditions.
So it sounds like a tightrope act on some level. Other perspectives on this question from your various jurisdictions. Tat, can I call on you?
Well, I think one could say that maybe in my part of the world and not just strictly in Singapore, mediation, I suppose one could say that the structure is facilitative, but the practice tends to evolve into evaluative. And somewhere in, I think, our discussion today, I would probably like to sort of talk about what I sometimes call the 9:30 style of mediation, as opposed to the 5:30 style of mediation. The former starts very facilitative, partly because that's how mediators are taught in this region. And then, as the day evolves, there is almost, one might say, an expectation by the lawyers as well as parties to ask the mediators to express views regarding merits of the case, and how the mediator sees the partner working out if the matter is not resolved.
Mhm. Very interesting. Other perspectives. Jerry, did you have your hand up?
Sure, I'll be happy to chime in. First, thanks a lot for including me in this august group. Very, very privileged and honored to be part of this conversation. I'm going to pick up where Tat left off, because in the United States, I agree, there's a 9:30 a.m. style of mediation and then a 5:30 p.m. style of mediation. And almost all mediations, at least that I do, start off as at least facilitative in character, where you're hearing from the parties. Of course, in my practice, I will have received extensive briefing from both parties, sometimes a couple of rounds of briefing. And if the case is pending in court, I will have also received the briefs that have been filed with the court. So that forms the foundation for conversation. But I think it's fair to say that in the United States, especially where former judges are involved as mediators, the parties want to know what our opinions are, because after all, we've been in the seat making decisions, and they want to know what our opinions are on the relative merits of their case, particularly on legal issues, but also factual issues. We, of course, have a jury system in the United States, and they're very anxious to hear from me what I think a jury might do with a case, as well as if there's dispositive motion practice, how a judge might regard their dispositive motion filings and the opposition briefs to the dispositive motion. So it does become evaluative fairly quickly. I don't think it probably wouldn't be accurate to say that it waits until 5:30 p.m. to become evaluative. In my cases, it will often start, very, very soon with questions to me. They'll have very pointed questions. And I have to say, I don't think that parties would hire me and pay my rates if they weren't interested in what I had to say about the relative merits of the case. I try to be circumspect about how I approach that, but I'm pretty honest with the parties. If I think there are strong merits or strong deficiencies in a party's case, I'll be pretty straightforward about telling them that and what the ramifications of that might be for them. Some mediators use what we call a mediator's proposal, usually at the end of the day. I try to stay away from that because it tends to freeze the process. When the mediator steps out and makes an actual proposal for settlement, it tends to freeze the process. I instead use a different process in which I try to move the parties together by setting ranges and getting the parties into ranges. Some mediators call it brackets. I will often do this, not always, but often do it through what I call double blind or black box approach, in which I don't.
Jerry, we'll get into some of those techniques in just a minute.
Okay.
Let me see if we could still hear from Andy and Andrew about maybe the UK perspective. I hope you agree on whether the UK is more facilitative or evaluative, or maybe not, and that might be an interesting discussion.
I think so far as the UK is concerned, and most particularly England and Wales, you need to put the subject into its proper context. So for the most part, mediators here are selected because one, at least, of their attributes is the ability to appraise, either at the outset or through the first part of the mediation process, the parties' respective positions, whether acting with legal knowledge or with subject matter expertise or as specialists. However, even though that's the basis upon which they're usually selected, they don't offer that appraisal. Typically in the UK, and I think in most developing jurisdictions, civil commercial mediators are taught and expected to deliver facilitated mediation, in which the mediator is prevented from expressing his or her opinion on the merits. It's a self-constraint imposed upon mediators, firstly by their training, and secondly because they feel uncomfortable in view of the disadvantages. I appreciate there are advantages. Sometimes more forceful mediators will give an opinion whether it's asked for or not. But I think by and large, we are shy of grasping the nettle. Offering a view on the merits, either in respect of the disputes or sometimes even of the proposed settlement, is generally seen here as an anathema by a healthy majority of UK practitioners.
But it's interesting because you're also saying, or what I'm hearing you saying, is that the parties often do select the mediator kind of precisely for their potential ability to give a good evaluation.
Yeah.
But it's the mediators that kind of constrain themselves.
That's correct. They're trained in a facilitative model, and whether there is a market demand or not, and whether lawyers themselves would feel it better meets the needs of their clients, I think there's a great self-inhibition because of the way the mediators are trained here.
So personally, I think that's really interesting because my take on, what's happened in the US is that, as people have mentioned, the traditional trainings have always been facilitative in nature, right? But I think in the US, we had such pressure from lawyers to move into a more directive and evaluative format. And a lot of mediators end up kind of caving to that demand, because they are the ones who end up, selecting you at the end of the day.
Well, JAMS was founded as long ago as 1979, and it's had 400 retired judges on its staff, and you can identify why there was a huge market demand in the States for that. But curiously, when it was tried in Europe, it's failed. The JAMS Europe office has collapsed.
Mm-hmm.
I think the other thing that you need to understand is that the facilitative model, it still masks what mediators actually do in practice, because we engage in hidden evaluative mediation in certain parts of the facilitative process. And if you ask Michel Kalipetis, he will tell you that all mediators evaluate all the time, because one of our functions is critical analysis. What's going on? What are we hearing? What's not being said? How can that not be an evaluation? The only distinction is we feel constrained not to deliver an opinion on the merits for a number of reasons, which I'm sure we will get to in the course of this discussion. And I can identify 8 reasons in particular why we're not going to go along the evaluative route.
That's fascinating. Andy, your perspective.
Well, I'm very fortunate to get to go last, and everyone's made all the good points. So I think I was going to say there's an issue around the when, and Tat and Jerry have covered that very well. And in terms of the Andrew summed up the UK very nicely, I think. I think there is an element as well in the UK and elsewhere where where lawyers will say, I want an evaluative mediator, and what they mean is I want a mediator who will tell the other side they've got a bad case. And actually, in the heat of the mediation, when it's staring them in the face that the mediator might actually do that to them, tell them they've got a bad case, they're not quite as keen on that element of the mediation. And also, as Jerry was saying, the mediator's proposal does kind of close down various avenues for further discussion. But I couldn't agree more with Andrew that actually there is a lot that the mediator is able to signal without being directly evaluative. But that might be, as Tat was saying, very different from at the beginning of the mediation towards the end of the mediation.
Yeah, terrific. So let's move on, if we can. And this kind of touches on some themes that Aşiyan brought up, but I'm curious if you have noticed whether mediation has evolved over time in the direction of maybe more evaluation or more facilitation, or perhaps even in the direction of eschewing or even transcending that distinction. And maybe this also ties in a little bit with what Andrew was saying earlier. Andy, can I now start with you first?
Yes, yeah, and because I think looking back, so I've been part of CEDA's faculty. I've been with CEDA for over 20 years now, and I've been part of CEDA's training faculty for I've lost count, 15 years maybe. And just in my time, there has been, I think, a movement there. There is particularly where the market is more sophisticated, there's a more relaxation about what is tolerable. And so whilst the basis of the training, Andrew's completely correct, is very much focused on the facilitative mediator. I think in terms of what people are comfortable in terms of evaluation is now quite wide, and a skillful, going back to what we were saying before, a skillful mediator can put a question mark at the end of almost anything, and all of a sudden it's a curious question rather than an evaluative statement. So I think that there certainly when in the UK market, but also particularly in many sophisticated legal markets, they will talk about an evaluative mediator, but there's an understanding that actually that evaluation might only go so far. It's not going to be the mediator sitting down, as Tat was saying at the beginning of the day, saying you're right, you're wrong. It might be that, as Jerry was saying, that there's signalling as the day goes on. Actually, if a case like this were to come in front of me, or in my experience, this is what tends to happen in trial. But I think going back to what Andrew was saying before, there's a lot of strategic decision that goes into the choice of a mediator, and how's the mediator going to work with my client? I want a mediator who I know that my client's going to be quite difficult, or I know the other side's going to be quite difficult. I want a mediator that's going to slam their fist on the table and get the attention of the room. Whereas thinking potentially, well, actually, everyone might burst into tears because this is quite emotional, and therefore I want a mediator who's going to tread quite softly. This personal style of the mediator can feed into the level of to which they will be facilitative versus evaluative. So I think that where mediation is newer, people are more nervous, a facilitative mediator is perceived as less dangerous. But where the market is more sophisticated, then or used to the concept of a mediator being potentially evaluative, then yeah, attitudes can be different. But I'd be very interested in hearing others' perspectives on this. Who would like to go first in terms of contributing?
I have to say I feel aligned with you because we share the same jurisdiction.
Yeah.
So let's see. I mean, I've seen trends over the last 36 years in which I've been practicing. But I'm very happy to hear what's going on in other jurisdictions.
Yeah.
And I'm always interested in what's happening in Southeast Asia and Turkey.
Okay, I can go next.
Yes.
For Turkey, is actually the opinions quite changing. I seen, especially for the mandatory mediation model. For when we first started, it was seen for many lawyers by just a transactional period that they need to pass through. But now I'm seeing that they are much more into cooperative with the mediator and finding the solution together. Is into this also is related with again I need to say that for legal wise, for jurisdiction level, for guessing what is going to be in the court is question mark, is also seen like a gambling in that sense. So together with another lawyer as mediator, they are also happy to evaluate their cases. But when it's come to whether their client near them, since there are many lawyers and also practicing mediators as well, so this creates a little bit competition in sense of when if you are doing also legal wise review and merits of the cases near their client, so it's like seen as we are competing with also mediation advocates. So that's why when it is different whether you are participating alone with the mediator or whether your client is near that. Also for mandatory mediation level is lots of parties like a rent disputes as into participants are present without their lawyer. So in that sense, their expectation is much more evaluative in that this request come for the party side. But still there's also quite balance in that sense. If you push so much about the settlement, sometimes parties make it reactive. And also for voluntary based to the decision between who is going to mediate and when you ask lawyers, they are selecting mediator that they work together before and also easily good communication. But when it's come to business, how they select a mediator, they want somebody that can influence the other party. So in that sense, the selection criteria are different in about other than for context level or expertise level, they are looking for authority level for business side, whether this mediator can convince the other party is about the agreement to mediate and also for negotiation again. And most of the time when the lawyers are attending, I'm seeing my role is about also helping the communication as well. And today I just closed in a commercial case. And also this case was in the other mediator's hand as well. And we closed nearly 7 cases in the same settlement agreement. And what I did is not really evaluate the case merits, is helping them communicate and to renegotiate about the process, because many times when lawyers and the parties were negotiated before and all failed. So for me is for them to convincing and to negotiate again and try once more, and it succeeded. So it's not for me when I seeing is most of the time when the case come to me, there are communication barriers, especially also including lawyers as well.
Yeah, I really like your point, Aşiyan, that actually the attitude of the parties is a big determinant in terms of whether the mediator should be more evaluative, or whether there will be resistance to that. Jerry?
Yeah, I'd like to pick up on something that Andrew said, which is that it's possible to be subtly evaluative by sort of putting a question mark at the end of a statement. And that works sometimes. But there are parties who escape the subtleties and or at least are blithely oblivious to them, and it requires a little bit more direction. I've even had, and I ask my colleagues if they've had the same experience, because it's happened many times with me, in which a lawyer will take me aside in the hallway and say, "Judge, you have to be much more forceful with my client. He's just not getting it, or she's just not getting it. My client needs to be hit between the eyes." That happens and usually it's clear to me that the lawyer has not been able to manage expectations very well in his room, and the lawyers will ask my assistance in helping. In those cases, I think those really cry out for a more direct approach. You can call it evaluative, but a more direct approach. Every case that we do, I'm sure this is true for everybody, has each side has strengths and weaknesses, and there are many toggle switches or leverage points that a mediator can use to move the parties, and a good mediator can pick up on those. So, the issue of evaluative versus facilitative will change with the issues of the parties.
Yeah, I think that's a great point.
I'm not sure that one shouldn't be slightly more blunt about this. I think the trend.
I was.
No, I mean, I'm talking about the subject matter of the debate. The trend, this apparent trend away from facilitation towards evaluation. I think that's. I don't see that at all. I think it's always been there. I think the idea that the mediator cannot and must not offer an opinion on the merits because they've been trained not to do so, I think simply a fallacy. And I think the fallacy derives from the fact that the mediator shouldn't be seen as participating in the decision making. But the fact is the mediator is a manager, and as a manager, the mediator makes decisions about the entire process in terms of participation, the order of events, the dynamics of the various meetings, the timetable, and irrespective of what kind of a mediator he is, he plainly influences the outcome, and therefore he's a key decision maker anyway. And I think part of this fallacy, or in fact this difficulty, should be laid at the door of the lawyers, because mediation grew up when the lawyers are still the gatekeepers of disputes. And I think that civil commercial mediation was developed in a way to remain under their own influence. And I don't see that as being something that's going to change in the future. I mean, lawyer mediators, they tend to have great difficulty in avoiding an evaluative style, even where the facilitative process demands that they should do so. And I think it's more a matter of suppression than abandonment. And it's obvious, because legal training, legal practice are entirely dependent on structures of procedure and procedural rules and rules of logic and legal thinking. And I think these all seep into an analytical approach to rights-based dispute resolution. And I think it means that the lawyer mediators have a tendency to go back to the orthodoxy of their original training. And they always approach, they tend to approach the problem on the basis that here is a case to be proven or disproven, and that conditions the approach to helping the parties settle, rather than this is a problem to be solved on a more opaque basis.
Do you think there's an element here as well, though, Andrew, in terms of how it's done? Because I think that there can be nothing more devastating than a well-placed question to the party or the party's lawyer, and then the mediator gives them some breathing space to actually think about it and ingest it, rather than the mediator diving straight in and saying, you're going to lose on this one.
But as we said before, isn't that more a matter of technique rather than substance?
Yeah. But the technique in itself can create the veil of facilitation, whereas in fact what the mediator, as you were saying, is doing is something more evaluative. Tat, we haven't heard from you yet.
I was going to say that I'm not sure whether this is echoed in other places, but certainly, I mean, where I practice mostly in this part of the world, in Asia, there are some scheme mediations, thinking about some mediations that are met up in nature, but within a scheme where the same panel would evolve into an arbitral tribunal if the matter isn't resolved in either a settlement conference, if you may call it that, but it's really intended to be a mediation. And in certain court-directed or court-annexed mediations where the judicial officers would actually mediate. And all of these folks would have gone through the courses or 40-hour courses where they learn predominantly facilitative techniques. But when they are in that space, the representations as well as the lawyers accept that it's going to be a highly evaluative sort of model. And when I maybe just talk a bit about what evaluative mediation means in that context, it would also involve the mediator plunging into the pleadings, talking about the legal merits one way or the other, and maybe even asking questions about, on both sides, what their case theory would look like in certain scenarios. And that, to me, sometimes, strains the concept of mediation, because you're going very much into what might, to the uninformed party, look like a neutral evaluation on a non-binding basis. But then there's also the other space, and I sort of, what Andy mentioned earlier on, sort of echoed in my mind, that in the purely commercial mediation space where you get to choose your mediator, I see a lot of my colleagues, when we act as the appointing party, we like to, determine horses for courses, or depending on the nature of the case, we may decide a particular case merits a subject matter expertise approach. And then we might decide, let's call someone who is steeped in knowledge in a particular sort of area, but we want that person to come in and be ready to evaluate. Or we might decide in certain cases we would prefer very much for the person not to be evaluative. Family cases comes to mind, matrimonial cases. And in that space, if a mediator tried to do something like that, he or she should not be surprised if the counsel, the lawyers, push back very vigorously against that sort of conduct of the mediation.
So one of the things I'm hearing is that context really matters.
Yeah.
And another is, I think this is Andrew Goodman's point, is that you can't really kind of exclude one or the other. Evaluation on some level is inevitable, and I wonder, that there was some writing in the U.S. Several decades ago where a law professor claimed that evaluative mediation was an oxymoron. So contrary to the fundamental kind of values or tenets of mediation. And Tat, I think you're kind of touching on this point. Any thoughts on that? Or is the more evolved view now that evaluation, has a place in mediation, is not necessarily contrary to some core mediation values?
Well, we use what I would call a soft evaluation. We call it reality testing. But there is a line which one can cross beyond reality testing, and then it becomes a pure evaluation. And I think it's a question of how you do it, the circumstances in which you create the space where you can deliver that kind of a message directly to the parties. as both Tat and Jerry have said, it often comes at the point of impasse rather than early in the day, because mediators will use it to get parties over the line when they're stuck, and they will tend to use it. I think, Jerry, there's an American expression called Batner bashing. The idea is that you're using it at the point where you're trying to reduce expectation in a party's Batner. And to an extent, even the most facilitative of mediators may find that as a useful device in order to get the parties home.
To that point, and I'd be interested in Tat's view of this. I've mediated a lot of cases with Asian companies, Japanese companies, Korean companies, Singapore companies, so forth. My experience is that the Asian companies that I've dealt with tend to make decisions more communally, almost by committee. And it's not unusual to have 5 or 6 or even 8 representatives from a party in the room, and then 5 or 6 or 8 representatives from the other party in the other room. And they'll take a long time to bat these things around. Whereas in America, there's usually one decision maker in the room. He or she will have others on the team with them, and they'll consult with them. But there's usually one decision maker, and you can identify that person pretty readily. And I'm just wondering, Tat, if that requires maybe a different approach when you have such communal thinking and decision making than we have in the United States.
Yeah, that's actually a fascinating piece. It touches on another part of I think a lot of us are interested in this cultural dimension of mediation. And certainly I think you can't say there's an Asian style, but I think when you look at, say, the Japanese style of decision making, it's often very collective, and they would huddle in groups, and no single person, at least in the cases I've seen, would have the ultimate authority. They often need to aggregate themselves, decide where to go from there. But then you move somewhat westwards, and you reach places like Vietnam, for example, or Indo-Chinese states, where they might form a committee, but this committee might still have to report upwards to a CE or someone who makes the ultimate decision. But the folks attending the mediation might have very limited mandate to deal with things. But I thought it might be useful. I recall that in the Singapore landscape, there was a time decades ago where a mediator mediating disputes or litigated disputes in the Singapore Mediation Center will object to a code of practice that says you will not evaluate unless the parties to the mediation make that request and you are persuaded or convinced you can make that evaluation based on your knowledge and experience. And then that guardrail was removed in a recent iteration of this code of conduct. And I suspect that it's, again, speaks about the evolution of where mediation is going in my part of the world, that it's almost accepted now that a mediator should be given the flexibility to engage in evaluative mediations. And it also speaks about data that we see in surveys coming through from lawyers and parties that, in fact, the very high percentage, I mean, I'm reading some survey results where 80% of a survey carried out by the Singapore Mediation Center practitioners opined that they actually had mediators who actually evaluated the merits of the case. That's a very high percentage. And it led one of the chief justices that we've had in the past to say that, to ask the question, pose the question, would it be correct to consider that perhaps in an Asian context, a mediator should assume a more interventionist role than that of a facilitator? I thought it was a fascinating question. But I think the jury is still out because, the state continues to evolve. But I suspect we are evolving into a model that's nuanced depending on, again, the kind of cases and the kind of disputes.
That's really interesting because it points up something that sort of predates cultural awareness, which is anthropological awareness in mediation practice. And I don't know whether Emilia or Michael are long enough in the tooth to remember, but Professor Michael Palmer, who used to lead the mediation course at SOAS, did a module on anthropology and mediation practice, in which it's perfectly plain that you can trace the faith, dignity, and honor cultures in the way that mediation works amongst those cultures. And that's why Jerry picked up immediately the fact that there was a communal approach in Far Eastern mediation, because it's simply a reflection of faith practice.
So we have a number of questions in the chat, but I wanted to pick up on one that I think is timely here. As mediation becomes more institutionalized globally, do you see the evaluative facilitative distinction becoming less important in the mediator's ability to adapt their style to the needs of the dispute?
So, as an institution that it has contracted dispute resolution, I can say that CEDA has an international panel of about 70 mediators and a UK panel of about 80 plus mediators. And within that panel, there are various different styles. Every mediator is encouraged to explain what their mediation style is. Plus, they have their reputation. So I think mediators are a lot of the time being chosen strategically by the users based on what they will bring to the mediation. So I'm not too worried from my institution's point of view, because I think there's choice. But there will be institutions that have great reputations that just prefer mediators of a certain persuasion, and that's fine as well. That would be my thought.
I think you'll find a much greater emphasis on cultural understanding, and I think that that's going to have much more of an impact on the balance between evaluative and facilitative.
Can you explain that a little bit more, Andrew? What do you mean by that?
I think both in mediator choice and in the needs of sophisticated parties or more sophisticated representatives, the impact of cultural awareness in cross-border or international work is going to be quite profound. And I think that there will be a trend to reject forms of what I call Western arrogance, in the way it's assumed that the process that the West has developed can be superimposed on ancient cultures that have much more of a hinterland in a mediative approach than our rule of law. I mean, our rule of law systems, they probably date back not much more than 1,000, 1,200 years. And I'm constantly bumping up against deep-rooted systems of mediation, which date back in the East for many millennia. And it's something that is going to come to the fore rather than this Western model that's been created in the last century and exported around the world, almost as a post-colonial attempt to revive justice coming from the West. I mean, I don't want to exaggerate that or overemphasize that, but it seems to me that that's where the growth area is going to be.
Aşiyan?
I would like to just add actually following question and related with this one. I see there's a trend, especially for global supply chain level. You know, their disputes is quite complicated when it's come to child labor or environmental disaster. It's getting a lot of jurisdiction involved. Also, there are supply chain acts that the companies get penalties. In that sense, I'm seeing the trend is generally intervene as much as early, not become a litigation, and beforehand, even in conflict phase, in order to, they use the way that they started to use mediator, I think, in the field and more to identify the risk, evaluate the risks earlier, in getting the trust level in the parties, in the community level, and then finding the solution according to by negotiation way. And most of the time, many companies are started to also get their internal staff to training about mediation. And we will see, I believe, that more and more from other professions, especially for the field related, like in construction, there are many suppliers involved. So they want their engineers intervene in a negotiation phase or immediately in a conflict phase. The same for the big companies that working in globally in around the world in different jurisdictions. So they want their staff to identify, evaluate the risk, and mediate immediately, not make a big problem later on for them.
So we do have a comment from somebody. I believe it will become more incumbent on the mediator to adapt the approach to the needs of participants in the dispute as the process becomes more institutionalized. That's a very good point. So let's move on a little bit and talk about evaluation techniques. And Jerry, you started this conversation earlier. When and how can evaluation be particularly effective? Is it something that's only effective toward the end of the day? Can it be used in the beginning? And what kind of techniques have you used or seen used effectively?
You know, I think for all of us, it comes down to reading the room, both as to the decision makers in the room, the salient issues that are going to be important to the people in the room, and also timing. And all of us, I'm sure, are experienced and skilled in reading the room and making those decisions. So I'll just talk about a technique or two that I use. I don't do this in every mediation, but I will often, when the parties are very, very far apart, whether on just dollars or on issues, I will often use what is sometimes referred to by mediators who use it as double blind, or some mediators call it black box, where you get input from each party. If it's the amount, you get that, but the mediator holds that and doesn't cross-pollinate it with the others in the room. And even within that, some mediators do it differently. One of my colleagues doesn't say a word about what the other party's position is or what the bid and the ask is, just keeps it to himself. Others are more give signals. I'm in that camp. I will often, although I won't trade numbers, I will often say they've made a good faith opening offer. They're showing some flexibility. They're starting to move. I want you to do the same thing. Those sorts of things, and that's more to get the ball rolling. And then at some point, I will usually put a bracket out or a range with a low end and a high end, and I will ask the parties to get to the range double blind, meaning I will, if one party gets to the range, the other doesn't, I won't tell the non-accepting party that the other party is in the range. I'll try to cover this very quickly. This approach has three advantages. The first advantage is, at the very beginning, it does away with the sticker shock reaction, where a party will say, well, if that's where they are, why are we even here? We're ready to leave. The second is, it does cut down on what I call incrementalism, where parties are moving very, very small moves at a go. And it cuts down on that because the parties have confidence that their offers are not going to be shared. But maybe the greatest advantage that gives the parties the greatest confidence is that they know if we don't get to an agreement at the end of the day, that the other side won't know where they are. They won't know what their last bid is, what their last ask is. And that gives parties confidence to move forward. And then it will also set a stage for a second mediation, or even a third or fourth or fifth, as in the case of the Detroit bankruptcy, the fifth or sixth or seventh or 12th month. So the practice is good. I found it as a tool. As I said, I don't do it in every case by any means, but I found it as a way to get through what seems to be a stalemate and to move the parties closer. And then the next question is, assuming the parties get into the range, what do you do next? And there are a number of ways to navigate that. I can talk about that too, to get the parties to yes and get the parties across the finish line.
Yeah, please do, Jerry.
So assuming both parties get into the range, and I always try to make the range as narrow as possible. If we're just talking numbers, I never use each party's last bid, never. I always make it inside. And one way to do it is to narrow the range. I try to get agreement of the parties as to the next step and narrow the range. Another way to do it is to have the parties open the bidding, take the blinders off, and just, if they're close enough, do open bidding. And very often that'll work. The parties will be maybe surprised how close they are. And a final way is just for me to start gently at first, throwing out some ideas or throwing out some numbers about numbers that might settle the case, and testing, test driving numbers and prying a little bit. I try to be gentle about it at first, at least. And it's surprising how many times, and this maybe goes to the nature of my practice versus others, how many times the parties will ask me to do the latter and to make suggestions at a settlement amount. Now, very often that's not the first session. It's the next session or even the next session after that. But it does have the effect of keeping the conversation moving, which after all is what we want to do. We want to keep the parties talking. We want to keep the parties negotiating. We want to keep the parties moving together.
So it sounds like you're very proactive at suggesting possible solutions, possible numbers, or can you go this high or can you come down this low, something like that.
At a certain point, I am.
Yeah.
But my first goal, if I'm using this technique, my first goal is to get the parties into the range, which happens at least in 80%, maybe even more, 90% of the cases I do, no matter how large the case is. Numbers are just numbers. They reflect values, of course, but numbers are just numbers. And sometimes even smaller cases are harder to settle for various reasons.
Other techniques or tips that panelists want to share a lot in the evaluative vein?
I can talk very briefly about early neutral evaluation if that's helpful.
Yeah.
So CEDA does some training on this, and there's not a lot out there. And I think one of the reasons is because early neutral evaluation can be very, very simple, or you can put a lot of process design into it. I mean, one of the key features is that it's a non-binding process, which means it's very safe. But I think in order for E&E to be effective, it's not something that should be just entered into without any thought. And it certainly, I would have some concerns. I think a mediator's proposal is a far better label for suddenly switching gears in the middle of a mediation, because with an early neutral evaluation, in terms of the process, you need to decide, are the parties just looking for an evaluation, or are they looking for an evaluation and a recommendation? Because those are two slightly different things. Do they want to have hearing elements? Do they want to? How do they want to present their cases? So there's all sorts of different areas. We are seeing an increase in E&E in certain walks of life. In particular, there's been more of it in clinical negligence and personal injury disputes. Family businesses actually is seeing some use of E&E because the family recognizes they need a route out of the decision, but they recognize in a mediation it's going to be too difficult for the family to actually decide, so they want to hand that over to someone else. And also some custody disputes as well. But with custody disputes, it tends to be more of an informal judge-led conversation that will end in a recommendation. So there is a range there, and it's happening. But I would say that it's a process that's worth considering, and there are a lot of mediator skills that could be utilized, particularly if they're looking for a recommendation as well, because then the neutral can use their skills as a mediator to look at the underlying interests to put into a recommendation. But at the minute, I would say the process E&E is still relatively rare, although increasing, but separate from mediation.
So I do note that there are some comments and questions that it might be good to bring up now, but I just wanted to give the other panelists, if you want to chime in on this thread, maybe I'll give you that opportunity first before I turn to some of the questions.
Maybe it's just useful to also say that, and I'm not sure this happens in places other than in Singapore or Asia, where again, nature of disputes, right? Certain kinds of disputes, the lawyers are ready to come in and debate what the question of liability or quantum should look like. Certainly, for example, in medical negligent disputes, lawyers tend to come in before the mediator, and if I'm the mediator, you would expect the parties be ready to even provide arguments on why the range of a settlement outcome should be between A and B, because the precedent, the cases that would support that range is this bundle of authorities, and then you get pushback from the defendant. But essentially, they are aligned in using the case precedents to determine what should be a fair outcome in terms of the range of possible outcomes, which I think brings us into very much the evaluative range, except that it's pretty much the lawyers doing the evaluation and the mediator being the chair of that meeting, facilitating that discussion.
No, that's really interesting. And also it strikes me that some of these techniques like ranges, and Jerry was talking about the double blind process, and Andy talked about mediators' proposals, they're not necessarily evaluative. When I do a mediator's proposal, I specifically say this is not a reflection of my view of the merits. It's really what I think is a number that both of you can agree to. And so to me, this kind of raises this issue of nomenclature. I think directive mediation is often confused with evaluative mediation. And I think, some of these techniques kind of straddle both. But anyhow, let me just voice some of these questions and comments. So Michael Bartlett says that Michael Palmer highlights the perennially recurring role and the recurring form of the mediator in anthropological research. His experience of Chinese evaluative mediation would be a fascinating addition to the conversation. And then we have another question. Do you think it is necessary to have guardrails between evaluative mediation and soft litigation? That is to say, where increasing preference is expressed towards hiring retired judges, perhaps with less sophisticated users, and does that lead to less than satisfactory outcomes? Do you see that slippery slope coming to pass? Any reflections on that comment or question?
I'll just say I support retired judges, of course, as a retired judge, but I also recognize that practitioners and experts in the area can be helpful. And sometimes if the case is large enough to justify the cost, it's helpful to have both a retired judge and an expert or experienced practitioner. In the Detroit bankruptcy, I appointed 6 co-mediators to deal with, we had 170,000 creditors. We were able to group them, but I appointed 6 co-mediators, and we often co-mediated. And sometimes that's a very good way to get the benefit of both. I think it's helpful to the parties to have that breadth of experience, and not just experience, but maybe breadth of approach. I'd just like to add a note to the mediator's proposal issue. I said it earlier, I'll maybe say it one more time. I try never to do what I call a mediator's proposal. Every once in a while, I have to do it at the end of the process when the parties are stalemated. But a mediator's proposal tends to freeze not just the process, but the mediator, because where do you go from there? If a mediator puts a proposal out and says, here's what the proposal is, the mediator doesn't have much room to move.
Just to chime in on this, sorry, Andrew, do you want to go ahead?
No, Tat, you go.
Right. Well, the guardrail, I think that my compatriot Linda was referring to, I think one great guardrail would be for parties to engage an experienced mediation advocate, someone who knows what he or she needs to do in a mediation, which starts from selecting the right mediator, and if the mediator goes off the rails, someone who is a strong mediation advocate would, bring that neutral back to the straight and narrow road. And certainly, I mean, from my experience sitting by the side of the table rather than the head of the table, I mean, there have been occasions where I might even come to a point in a joint session where I'm find the mediator trying to evaluate. One case comes to mind very recently where I articulated, I said, so and so, you might know what you're doing and the lawyers, might know, but my client would not appreciate you putting that statement out there in a joint session. So I appreciate if you stop what you're doing and go back to just facilitating. I mean, I actually said it like this. And then he adjourned it. He spoke to me and I said, well, I don't appreciate this going the way, Joe. Can you just bring it back to a facilitative model? But, those are the things that an experienced, I suppose, advocate can do in order to bring it back back on track.
And it really underscores the importance of mediation advocacy.
Yeah.
Yeah.
Well, I'm very pleased to hear that, since that's my particular field of interest.
Mhm.
But I mean, what worries me is that the trend towards encouraging evaluation, and even the desire to have some kind of evaluation, obscures some of the core dangers that there are in doing so. And I think that lawyers who instinctively are inclined to ask for an opinion or ask for some guidance in respect of the merits from the mediator, they need to understand that there are a number of real risks, the first of which, of course, is loss of neutrality. Because it's unlikely that the evaluation is going to please both parties, obviously. It's quite possible that it'll please neither. And the result, obviously, is that at least one of the parties will see the mediator as partial to the other side. And in that perception, the mediator is no longer going to be able to fulfill a neutral role. And what does that mean? There's a likelihood that one party will want to leave the process because they believe it to be tainted. So it creates an additional burden on the mediation advocate to persuade the client to keep faith with the process and to keep faith with that mediator.
I'm really glad that you made that point. We actually have a question on this very issue, and it is only 15 minutes left, so I think I'd like to start transitioning to the Q&A period, if that's okay. But we have a fascinating question from a master's student at Leuven, who is currently writing her thesis on the neutrality of the mediator and the balance between facilitative and evaluative mediation. Apparently, in the Belgian Code of Ethics for Certified Mediators, neutrality is interpreted quite strictly. Mediators should not give advice that could influence the resolution of the dispute. So the question is, from your international perspectives, where do you see the boundary between maintaining neutrality and adopting a more evaluative role? She's also wondering whether you see particular legal or regulatory issues arising from this distinction. Are there jurisdictions where This debate has been addressed in an especially interesting way, for example, through regulation or case law or ethical rules. Any thoughts about that?
Well, I don't think it's I'm sorry, Andy. I don't think it's simply a question of loss of neutrality. I think that there's a danger in respect of confidentiality as well, on the basis that the mediator is likely to evaluate on the basis of confidential information that he's received. And it may be that in expressing an opinion, that confidential information is revealed or can be inferred from the mediator's proposal or the mediator's opinion. That leads to loss of ownership by the parties, which is fundamental to the process. It may create entrenchment by the party who has a new position to defend. It may give rise to the need to vindicate a particular position. And therefore it leads to collusion, because if the mediator expresses an opinion, then the party in whose favor the mediator's opinion lies is going to want the mediator to persuade the other side on the basis of that opinion of something which may be of less merit to the party that is losing the opinion. And of course, the real danger, irrespective of loss of neutrality, is the injury to the client-lawyer relationship and potential loss of face in respect of a case that the lawyer has promoted, which the mediator is now going to say there's no merit in, or there's less merit in. It's a real issue. If you ask me about regulation, one of the things I would point to is insurance provision. I don't know about Tat and Jerry, Andy, or indeed Aşiyan. My insurance, my professional indemnity policy as a facilitative mediator is pretty cheap. If I started evaluating and marketing myself as an evaluative mediator, I rather suspect that my insurance premium would significantly increase.
I mean, I think that's also an interesting point, and it dovetails with the question that Michael Bartlett asked in the chat earlier on. You know, does giving, when the mediator gives an evaluative opinion, does that actually amount to giving legal advice? So that's question number one. And then we have another question. It's similar. At what point does reality testing become evaluation?
Mm.
And is there a meaningful boundary between the two? And if so, how do you identify that? Andy, do you want to try?
Yeah, I was. So the point I was going to make, which kind of applies still here, is going back to the point about directive mediation being confused with the mediator is capable of making a lot of process choices, and sometimes some of those process choices can help get around or get to the same point that taking an evaluative approach might do. So deciding that from a process point of view, that actually there needs to be a conversation about this first, and to do it in a particular environment, to do it in private session, to do it in joint session. So there's various things that could kind of achieve the same end without kind of going over the line of saying your case is weak, etc. So so I think there is that element to it. In terms of the reality testing, it all depends how it's done. And Jerry's right. Sometimes the lawyers do want the mediator to deliver a sledgehammer to their clients. But a lot of the time, it is possible for the mediator to get there with more gentle probing that will kind of let the message dawn on them. Obviously, there's a difference here in terms of what you can do in a short mediation and a longer mediation. And from that point of view, I'd be quite interested in hearing from Aşiyan in Turkey with mandatory mediation, what it's possible to do in terms of reality testing when presumably you've got a slightly shorter mediation?
Actually, we have quite recent some complaints about mediators, and a couple of years ago, we made a survey within the framework of EU project, and we had some comments from the public level as concerning this issue, as clearly one of the consumer dispute, consumers saying that a mediator told me that I have a very weak case, I have no chance to really win the case, and I will lose money, I will lose time, etc. So he tried to convince me and push me about to settlement, and I refused. And I go to court and I win. And so if I lose the case by trusting it, the mediator saying, so I will have a really not good settlement, and even I cannot win the case. So then, and he go to directly to complain about me to mediator for losing the neutrality. So our law is saying is we cannot advise, we cannot really provide as to solution, but there's a small exception is at the end of the process, if we see there's still an option, we can propose some solution, but it depends on the mediator. You don't have to, but if you feel that there is an option or proposal wise, the law allows. So the law itself, and although there's clear distinction, we cannot give legal advice or legal evaluation, but and for the solution level, we can encourage parties for alternative solutions. So reality testing is a part of it, and to questioning about possible solutions, and also evaluation about the case for the risk analysis still possible as a technique, but not giving a clear to evaluation about what's going to happen in court.
So we have only about 8 or 7 minutes left and still a few more questions in the chat. So I wonder if we could try and get through these questions. We had one for Jerry from someone who mediates in England and noted your comments about what the US legal profession wanted or hoped from mediators. I wonder whether that has led to directions like the American Bar Association Formal Opinion 518. I've been reading so much about seeking to control behaviors and statements of mediators. I observe it says that mediators should, quote, be careful not to make misleading statements about the strength or weakness of a party's case. Of course, but it is implicit in that it is accepted they can express a view. How do such directions affect your view in relation to today's topic?
I'm, of course, aware of 518. All of us are. I think you have to understand a little bit about the background. I'll try not to, I won't dwell on it, but it comes from a background in which the parties are not always equally sourced in terms of the resources that they have. And the concern that gave rise to 518 was that if the mediator sort of joins the fray, that it will add to the piling on of the weaker against the weaker party. That's where it comes from. You know, I understand the opinion. I don't agree with it. In my practice, people wouldn't hire me. I think that would be true of most of us at JAMS, and certainly the retired judges, if they weren't interested in our opinions. And as you said, there's an exception. But yeah, I'd like to just take 30 seconds to address Andrew's concerns that he raised, which are legitimate concerns. And a lot of those concerns about partisanship, treading on people too heavily, joining the fray on one side, I think a lot of that can be allayed with the way in which the mediator conducts the process. If the mediator gets buy-in to the process and listens to the parties and has an open, candid discussion with the parties, the mediator's evaluative opinion won't be a surprise. And sometimes, and it certainly happens, when I engage with the parties and I hear from them, sometimes my opinion changes, and I'll tell them they've made good points that I hadn't thought of. But if the mediator is interactive with counsel and the parties, and gets buy-in with the process, I think you can address some of those partisanship concerns.
I recognize that. I have a model for how you would actually approach delivering an evaluation. But the core concern I have, well, there are a couple of concerns. The first is there is a lacuna in circumstances where you're giving an evaluation based on very limited information. In this jurisdiction, we have no rule of discovery or disclosure in mediation. The mediator has no power to direct disclosure or discovery. There is a power imbalance between the parties in circumstances where information is deliberately being withheld. And the last thing you want is for the mediator to become a conduit for misrepresentation. And there is ultimately some kind of protection for people, because if you end up with a mediated settlement agreement which operates as a contract, then the law simply will say any contract that is brought about as a result of misrepresentation, fraud, mistake, undue influence, economic duress can be set aside in the same as any other. But since it's a confidential process, it may never emerge that the settlement came about as a result of any of those things. That, I think, is one of the weaknesses in relying on something which is brought about through evaluation. The second thing is, and I forgot to say this, evaluation narrows the focus on potential outcome because it's still bound up in the original case or the original claim. The facilitative mediator can say, let's talk about something else. Let's not talk about this dispute. Let's talk about options for mutual gain which exist outside the case, so that both parties are made better off by taking the case, putting it in a box, putting the lid on, and putting it in the corner. And that's something you cannot do with an evaluative approach because it narrows the focus of the party's attention.
So I'd like to get one more question in because this person's been waiting for a while. And we might go a little bit over, but we also started a bit late, so I hope that'll be okay. So this question is for Andrew Goodman. And the question is whether in a situation of a mediation between two states and a mediator appointed by the UN, should he have the same behavior as you just described? So this was a while back. Mr. Messini, I would invite you to just explain what you mean by the behavior that Andrew had described earlier. If you want to unmute yourself. Mr. Messini?
I was first approaching the chat, but as you mentioned that I unmute myself, I just did it. So it was at the beginning where the dilemma was actually articulated about the evaluative approach versus the one which is the main theme of this gathering, and then Mr. Goodman disagreed. I hope that he just remember what part of the discussion it was. And if I may expand for just shortly, in a situation when we have a mediator which is appointed by the UN, of course there is a mandate which is quite clear, redacted at the beginning, etc., etc. But as an approach, evaluating or giving the opinions and the counsels to the parties, it's something which is seen as a danger by the parties, or it is something which is seen by as a helpful, actually. Hope it was clear.
I think that what you describe is likely to be the subject of express terms of reference. I think the parties who agree to a mediator appointed through the UN in respect of interstate conflict is likely to have very clear parameters set as a result of his appointment. And I'm not convinced that the distinction between evaluative and facilitative is terribly helpful in that context. I think that the degree of direction that the parties are prepared to accept is more likely to come into play. And frankly, I think that you're asking the wrong person, because I think Tat is much more likely to have experience in this area than I do. I do recognize that the force in the question, particularly in the times in which we currently live. I think it's important where you have very large, very complex disputes, or disputes between huge entities or states, that the terms of reference of the mediator are laid out in some degree of detail and quite expressly, so that the parties have confidence in knowing exactly what the mediator is going to be able to do, and also what the mediator is not going to be able to do.
So, Tat, if you want to very briefly respond, and then we should really close out the webinar.
Yeah, I think this question touches, one could say a somewhat controversial part of how work is evolving. Certainly the work I do in mediation of World Bank disputes, sometimes between communities and states, between communities and companies funded by World Bank. We have moved away from the strictly facilitative model, believing that we're just there to help parties discuss, find their own solutions, to a model that looks very much like, and some might say controversially, like we look for what we think might be an equitable outcome that takes into account the needs of the parties, and then we try to steer the mediation in that direction. And some might call this mediators advocacy, but it's a subject matter which David Hoffman has spoken about sometimes. But I think it's well beyond the scope of, but certainly I think it's food for thought as to whether a mediator should, look at what a dispute looks like and say a great outcome would be this. And should we not try and steer party towards that outcome? But, that's something which we can all mull about.
Terrific. Well, our time unfortunately has come to an end, so let's give a round of applause to our panelists. Thank you so much for joining us and for sharing all of your insights and experience on the panel. And thank you all for also joining us in the audience. It was really terrific to get your excellent questions, and I hope to see you at a future webinar.
And thank you, Hiro.
Thank you.
Hiro.
Thanks a lot.